Administration is the principal alternative to liquidation for an insolvent company and offers some significant advantages to proceeding directly into liquidation. Accordingly, if you are a director of a limited company that is in financial difficulty, you need to consider whether administration is appropriate in your circumstances. To help with this decision, it makes sense to understand the background to the current set of rules and how it works in practice. The new administration procedure came into force on 13th September 2003, at which point it changed from costing about 10 grand on a good day to exactly £35. £5 to a lawyer to affirm the application form signed by the director, and a £30 court fee for filing said application form at the High Court. The procedure is out of court, as in there is no hearing in front of a judge. Once the necessary forms have been filed, the company is in administration. It's frighteningly easy to do, for the grand sum of £35. For your 35 quid, all current legal actions against the company are stayed, as the company has the protection of the court as soon as the application form is filed. No new legal actions can be commenced while the company is under the court's protection, without either the consent of the administrator or the leave of the court. The procedure was simplified somewhat, the original format having been created in the 1986 Insolvency Act, with the intention that it would be the UK equivalent of the Chapter 11 company rescue procedure in the USA. The original administration procedure required a full hearing in the High Court, with barristers speaking and solicitors drafting the application, and the proposed administrator preparing a detailed investigative report on the company's circumstances and survival prospects, all very expensive and accordingly little used by small companies due to the prohibitive costs, with the unintended consequence that small companies that might otherwise have had a chance of survival could not afford to seek the protection of the court, which administration offered. Consequently, for smaller companies, the survival of the business, not the company, was left to the perils of voluntary liquidation and a post-insolvency asset transfer to a new company, often owned by the directors, shareholders or management. A process not without its efficiencies, an often similar outcome. As a result of the cost barriers faced by smaller companies, the procedure was reformed with a view to streamlining the process of applying for administration and, as I mentioned before, substantially reducing the cost. As a result, administration is now a realistic option for any company that qualifies and is increasing in popularity as compared to the old version and the alternative of voluntary liquidation.